Okay, we're going to look at activism flows, and we make a distinction between activism and what their argument is legitimacy. We're saying that activism, the internal links to our dissent is that activism is important to maintain the co-equal authority of the branches. When you don't have that, then the branches start to just say, oh, well, we can do this because you did this, because you abused your authority. That's the internal link. It says that the impact of activism will lead to tyranny at the point where one branch thinks that they can do anything they want to, and the impact of that is that it kills millions and it destroys the rule of law. So what you're going to look at is weigh that against case. All we do is win a risk of the fact that the case is activist. That means all we do is a risk is that the case is overruling, and we're going to get that, and then it functions as a net benefit because we're not overruling. We are distinguishing. Therefore, we'll get a risk of this external impact now in the flow. Off the first argument, they say the court's legitimacy is down right now. What you're going to extend across the original uniqueness from the shell says that, look, the Roberts Court is not going to act activist. It doesn't matter whether or not the legitimacy is perceived by a couple of individuals because their evidence is citing what people think on the streets. It doesn't really matter what people think. It's just as long as they're acting within their limits of Congress. And then off the second argument, they say, well, we solve legitimacy, but again, across by the analysis that as long as they're acting, they're not abusing their power, they're not edging into presidential power, they won't be activists, and so it's not a non-unique argument. At best, what they're going to use this evidence to do is access the impact, but they won't be able to do that at the point where the internal link is discussing activism, not the court's legitimacy to the public or the court's legitimacy to other countries. On the link debate, off the turn, failure to defer to Congress's activists, Marshall 102. I will try somewhat to different track. However, when working in the concept of judicial activism, I've attempted to identify indices of judicial activism, often known in literature, non-originalist activism, the failure of the courts to defer to some notion of originalism in deciding cases whether the originalism grounded in strict fealty of the law, reference to original intent of the framers, presidential activism, the failure of the courts to defer to judicial precedent, jurisdictional activism, the court's adherence to jurisdictional limits within power, the use of judicial power to impose ongoing affirmative obligation in other branches of government to governmental institutions under ongoing supervision of the court, judicially imposed remedy. Also extend across the second link argument that's made from the 1NC. This, again, is the argument. It comes before their legitimacy arguments because it's a matter of perception. Immediately, Congress has to discuss how in which this interacts and how in which the presidential power is now going to be articulated, and that's the argument. Also, activism destroys legitimacy, which causes tyranny. Terry Peretti in 99. One of the primary arguments that conventional scholars the idea of political court policy motivation legitimacy crisis that will believe will ensue. They argue that the political court political attack will likely to lose its legitimacy, the primary source of the power. The loss of its power means that the court's ability to specialize valuable role. No longer will the court be able to protect its constitutional right, liberties and political vulnerable majorities from a majoritarian attack. And so this answers the legitimacy argument, saying that actually activism will decrease legitimacy if they do try and use that as a way to access the internal link. Also on the bottom they say no link. There is precedent to use international law and reasoning, but they're not applying international law to the decision. Number one, and number two, that's not relevant to the link debate. All we have to do is prove that they decrease presidential authority, which they do, and they overrule the decision, which they do, and that's where we get it. Now onto the distinguished flow. First off, they made we're going to win a risk that the counterclaim solves for the case. Off the first argument, they say no long-term solvency because Congress could declare war. But when Congress never declares war, and if they do, like Vietnam wasn't declared war, Korea wasn't, and if they do, it's limited by congressional budgeting, so it always has to come for annual review, like Iraq, and we just ended. And when it did, and when they declared the war over, so it's not like it can be an infinite. It's not like it can be an infinite. All we do is prove that we solve for the ongoing problem in the status quo, and that's how we access the internal links to the harm scenarios. That's true. They say they get a better time frame, but no, they can claim a better magnitude. We get the same time frame because the impacts are all happening now in an undeclared war, and that's all we do to prove it's solved. Also, extend across the second part on here that distinguishing specifically in this case, it can solve because it articulates how it articulates how the particular problems with the tribunals can be handled with the distinguished. Third, this solves for all the external impacts of the net benefits at the point where we're not overruling, we're just distinguishing. Off the third argument that it links to the disads just as much, they're trying to say that like any risk will be outweighed by SOE, but we'll capture that as much SOE as they do because we get rid of the state of exception. All it do is prove that we get rid of the tribunals and the problems that are going on right now. And two, extend across that distinguish evidence, the first distinguish card, it says that that the distinguish will work just as well, but it will get us out of the disadds because distinguishing is uniquely different than overruling. And lastly, the case will always have a greater risk to trigger the threshold of the disad at the point where it's more controversial. That's the same story that you're getting from us all throughout the debate. And on the SOE flow. I'm going to really quick. What you're going to extend across this first evidence, we read this card that said that in any type of liberal democracy, in every type of liberalism, what you're going to have is always a state of exception, because the majority rules, and that means the minority is always a state of exception. So coming out and claiming that, hey, we're fixing the state of exception is counterproductive and a problem. There's no response to this specific argument that we're making. That's our cone evidence, and like that. Like they have to solve for that in order to solve for the state of exception. Also, you're not getting any explanation as to how they're solving rendering. At the point where the executive will always just be able to render and send people somewhere else, that's the no evidence. They'll always be able to continue that.
That what, quart?
Yep.